Hello and welcome to What the F*** Just Happened Today, your essential guide to the daily shock and awe in national politics. I'm Joe Amditis. Let's get to it. It's Tuesday, April 19th, 2022. Welcome to day 455. The Biden administration says it hasn't ruled out appealing a federal judge's order that struck down a nationwide COVID-19 mask mandate on public transportation. White House Press Secretary Jen Psaki says the DOJ will take a couple of days to decide whether or not to challenge the ruling. Following the ruling, TSA said it would stop enforcing mask mandates, and most major airlines followed suit when it comes to domestic and some international flights. Biden said Americans should decide for themselves whether to wear masks or not, saying that the decision to mask is up to them. The CDC, meanwhile, continues to recommend that people wear masks on planes, trains, and other forms of public transportation. Meanwhile, the Supreme Court ruled that the Pentagon is allowed to take disciplinary action against an Air Force Reserve officer who refused to be vaccinated against the coronavirus on religious grounds. Lieutenant Colonel Jonathan Dunn, who was seeking to avoid being shifted to what's called Individual Ready Reserve, said he decided that the coronavirus vaccine violated his faith after seeing Biden speak about it, which led him to conclude that the, quote, vaccine ceased to be merely a medical intervention and took on a symbolic and even sacramental quality, end quote. The Supreme Court, however, issued a brief two-sentence order refusing to intervene. Clarence Thomas, Samuel Alito, and Neil Gorsuch all dissented. After being ordered to choose between being vaccinated, resigning, or refusing the vaccine in writing, Dunn instead sent a one-word memorandum to a two-star general saying, quote, nuts, end quote. Moving on, the Biden administration plans to scrap a Trump-era rule that allows healthcare providers to refuse to perform abortions or other medical services that conflict with their religious or moral beliefs. The so-called conscience rule was unveiled by the Department of Health and Human Services in 2018 and finalized in 2019, but it never took effect after dozens of states, cities, and advocacy groups sued. The HHS under Trump said the rule fulfilled a, quote, promise to promote and protect the fundamental and unalienable rights of conscience and religious liberty, end quote. HHS is now expected to rescind the rule as soon as the end of this month. Biden also says he'll restore stricter environmental standards for approving new pipelines, highways, power plants, and other infrastructure projects, reversing another Trump-era environmental rollback. The rule requires federal agencies to assess the climate impact of projects under the National Environmental Policy Act. The 1970 law requires an assessment of the environmental consequences of federal actions, such as oil and gas pipelines. In 2020, Trump claimed that the regulation needlessly hindered infrastructure projects and exempted them from review in order to speed up the approval process. Moving on, the Department of Education says it will grant federal student loan borrowers an additional credit toward loan forgiveness. The changes would apply to an income-based program for repaying student loans and bring more than 3.6 million people, nearly 10% of all student loan borrowers, closer to debt forgiveness, including 40,000 who will be immediately eligible. The current income-based repayment program allows borrowers to pay a capped percentage of their income on their loans for 20 to 25 years, and then have the rest of the balance forgiven. A 2021 study, however, found that just 32 borrowers out of a total of 8 million had enrolled in the program successfully and had their debt forgiven. The program has existed since 1992. The department, meanwhile, promised to address, quote, historical failures in the administration of the federal student loan programs, end quote. And finally, a federal judge allowed a group of Georgia voters to move forward with their attempt to disqualify Representative Marjorie Taylor Greene from running for re-election, citing her alleged role in the January 6, 2021 attack on the Capitol. The effort is based on the Constitution's 14th Amendment, known as the Disqualification Clause, which bars members of the Confederacy from holding office, as well as any person who has taken an oath to protect the Constitution and has, quote, engaged in insurrection, end quote, against the United States, or, quote, given aid or comfort, end quote, to its enemies. District Judge Amy Totenberg denied Greene's request to stop the lawsuit, saying, quote, this case involves a whirlpool of colliding constitutional interests of public import, end quote. And in the polls, 538 says 70% of the 111 candidates that Trump has endorsed for governor, federal office, attorney general, or secretary of state believe that the 2020 election was fraudulent. That's all for now. You can find the links and sources for all of these stories on the main website, And as always, visit whatthefuckjusthappenedtoday.com for the latest news and headlines. Until next time, I'm Joe Amditas.